you hear a lot of talk right now about the 14th Amendment. Does it confer citizenship on the children of illegal aliens who are born in this country? So I went back and I took a look, because we have members of Congress saying we need hearings on this. Well, there have already been hearings on this. And we don't need another constitutional amendment to amend a constitutional amendment that was already ratified by the states. All you need is a statute by Congress clarifying what was meant. I have a good friend. I haven't talked to him in a while. Professor of political science at California State University and senior fellow at the Claremont Institute, Edward Erler. And he testified on June 25, 1997, before the House Judiciary Committee Subcommittee on Immigration and Claims. And he has it exactly right. And why wouldn't he? He's an expert. If you really want to understand what's going on in the news and with these politicians, you really need to follow me on this, because we're going to take a little bit of time and break it down. You have people saying, we got to get rid of the 14th Amendment. Why would we do that? The 14th Amendment applies, among other things, the 5th Amendment to the states. The 14th Amendment was passed for a purpose. This was not one of them. So don't listen to the kooks who have no background in the Constitution or history, but for the most part, before they became broadcasters, were selling pills on the air, or diet supplements, or whatever. Don't listen to the politicians either, like Lindsey Graham, who want to divert your attention and have you chase a phony constitutional amendment, a new one, which will never happen. But also reject those Democrats and Republicans who say, let's not discuss this, let's not do this. Well, what is it? Do we embrace the Constitution, ladies and gentlemen, or not? I say we embrace it. We embrace all of it. Now, Professor Erler testified in part as follows. This is crucial. And by the way, we will link to it on marklevinshow.com, Facebook, and our other social sites. He said, it's my considered opinion that Congress has the authority, under Section 5 of the 14th Amendment, to define the jurisdiction of the United States. Senator Jacob Howard, the author of the Citizenship Clause in the 14th Amendment, defined who would fall into the jurisdiction of the United States. He said in part, every person born within the limits of the United States and subject to their jurisdiction is by virtue of natural law and national law a citizen of the United States. This will not, of course, include persons born in the United States who are foreigners, aliens, who belong to the families of ambassadors and foreign ministers accredited to the government of the United States, but will include every other class of persons. It settles the great question of citizenship and removes all doubt as to what persons are or are not citizens of the United States. This has long been a great issue in the jurisprudence of the legislation of this country. So clearly, Professor Eller points out, the author of the Citizenship Clause intended to count foreigners, aliens, and those born to ambassadors or foreign ministers as outside the jurisdiction of the United States. Senator Howard knew, as his reference to natural law indicates, that the Republican basis for citizenship is consent. Consent of the citizens. Consent of the governed. This is the natural law principle of the Declaration of Independence that proclaims that legitimate governments derive their just powers from the consent of the governed. Senator Lyman Trumbull, chairman of the Judiciary Committee and a powerful supporter of the 14th Amendment, he remarked on May 30th, 1866, that the jurisdiction clause includes those, quote, not owing allegiance to anybody else. He said it is only those persons who come completely within our jurisdiction, who are subject to our laws, that we think of making citizens. And there can be no objection to the proposition that persons should be citizens. This was familiar language. The Civil Rights Act of 1866 had defined citizens of the United States as, quote, all persons born in the United States and not subject to any foreign power, excluding Indians not taxed. It is universally agreed that the immediate impulse for the passage of the 14th Amendment was to constitutionalize the Civil Rights Act of 1866. This was an attempt to put the question of citizenship and matters of federal civil rights beyond the reach of simple congressional majorities. It is clear that the idea of allegiance, that is, not subject to any foreign power, was somehow central to the understanding of the jurisdiction clause of the 14th Amendment. In other words, not a citizen of another state, of another country. Now, much of the debate about the jurisdiction clause in the Constitution centered on the status of Indians. The immediate question was whether the 14th Amendment would confer citizenship upon the Indians as well as upon the newly freed slaves. The former slaves, of course, had been born in the United States and has always been subject to its jurisdiction. Was the same true of Indians? Indians were surely born in the United States, but were they subject to its jurisdiction in the sense that of not owing allegiance to anybody else? Senator Trumbull noted that the provision that all persons born in the U.S. and subject to the jurisdiction thereof are citizens means subject to the complete jurisdiction thereof. Trumbull proceeded to deny that Indians were in any sense subject to the complete jurisdiction of the United States. We make treaties with them, he said, and therefore they are not subject to our jurisdiction. It cannot be said of any Indian who owes allegiance, partial allegiance if you please, to some other government that he is subject to the jurisdiction of the United States. Remember, we're talking about the debate that took place relating to the 14th Amendment. The author of the Citizenship Clause, again, Senator Howard, emphatically agreed with Trumbull's assessment that Indians would not become citizens of the U.S. as a result of the passage of the 14th Amendment. He said the word jurisdiction as here employed ought to be construed so as to imply a full and complete jurisdiction on the part of the United States, coextensive in all respects with the constitutional power of the United States, whether exercised by Congress, by the executive, or by the judicial department. That is to say, the same jurisdiction in extent and quality as applies to every citizen of the United States. Certain gentlemen cannot contend that an Indian belonging to a tribe, although born within the limits of the state, is subject to this full and complete jurisdiction. The point is, if Indians back then weren't considered U.S. citizens, and by the way, not as an act of discrimination, but because they had tribal governments and so forth, tribal nations, how can it be said today that somebody who walks into the United States, delivers a baby, has suddenly on their own conferred citizenship on their own child? Simply because they're here and they claim jurisdiction. Again, it's not jurisdiction in that sense. Moreover, they cannot have allegiance to another nation. That is, Mexico, Ecuador, Bolivia, Peru, Russia, what have you. That is, citizens of those countries. Professor Eller goes on. Clearly, insofar as Indians owed tribal allegiance, they were not within the jurisdiction of the United States, even though they were born within its territorial limits, and in many instances subject to its laws. It is important to note here that jurisdiction does not mean simply subject to the laws of the United States. Rather, it refers specifically to the political jurisdiction in the sense of allegiance. Aliens in the United States are properly subject to the laws of the United States and the jurisdictions of its courts. But this is not the same as owing allegiance to the United States. Aliens subject to the laws of the United States still owe allegiance to another country and are thus not within the political jurisdiction of the United States, the only jurisdiction contemplated by the 14th Amendment to the Constitution. In 1870, the Senate directed the Judiciary Committee to, quote, report to the Senate the effect of the 14th Amendment to the Constitution upon the Indian tribes of the country, and whether by the provisions thereof the Indians are not citizens of the United States, unquote. The committee report noted that the inference is irresistible, that the amendment was intended to recognize the change in the status of the former slave which had been effected during the war, while it recognizes no change in the status of Indians. Professor Erler points out that it seems to be beyond debate that the jurisdiction clause of the 14th Amendment was intended by its framers to have independent force. Not all persons born in the geographical limits of the United States or within the jurisdiction of the United States. To be within the jurisdiction of the U.S. means to be within, again, its political jurisdiction. Those who today advocate birthright citizenship for children of illegal aliens born within the geographical boundaries of the U.S. seem to believe that the 14th Amendment extends to these children what the framers of the 14th Amendment said did not extend to Native Americans. In the case of the children born to aliens illegally in the U.S., their citizenship would follow the citizenship of their parents, or to be determined by the laws of the country in which the parents hold citizenship. The fact that illegal aliens have violated the laws of the United States precludes any possibility that they can be properly said to be within the jurisdiction of the United States, as the aliens surely have demonstrated that they do not believe themselves to be subject to the laws of the United States, or are only partially subject. Contrary to a currently fashionable argument, the denial of birthright citizenship to children of illegal aliens does not punish the children for the sins of the parents, because the children don't have a right to citizenship in the first place, which they are being denied nothing, so they are being denied nothing that is rightfully theirs. It would, of course, be a different matter for the children born of legal aliens who've been admitted by the laws of the United States. Whether their children would be citizens at birth or upon the attainment of citizenship by the parents would be a matter for Congress to determine. And finally, Professor Erler points out, Congress, of course, has plenary power. That means broad power. Under terms of Article I, Section 8 of the Constitution, quote, to establish a uniform rule of naturalization, unquote. By necessary inference, Congress has the power to regulate immigration and set the terms by which those who are legally admitted can remain in the country. It certainly can establish the standards for which the contract of citizenship can be offered and the qualifications of those to whom it will be proffered. He said and testified, I believe that Congress is fully competent under the 14th Amendment to pass legislation dividing those who are subject to the jurisdiction of the United States. It does not require a constitutional amendment to withhold citizenship from children born in the United States of illegal alien parents. Their parents are not subject to the jurisdiction of the United States, and they seek citizenship for their children without the consent of the nation. It defies logic to insist that an illegal act on the part of parents can confer the boon of citizenship upon their children.